Okay, any questions? No? Okay, let's continue. So, acceptance, the fact of acceptance and communication of acceptance. So let's talk about the first aspect, fact of acceptance. Acceptance is a final and unqualified assent to all the terms. So if you still remember, counter offer is an offer with some terms different from the original offer, right? But in order to have a proper acceptance, it should be final and unqualified assent to the original terms. A valid acceptance must be made while the offer is still in force. So as seen above, say, for example, passage of time. So it needs to be within that period. Otherwise, if the time has passed, lapsed, then the offer will become invalid. Therefore, the acceptance, you could not accept that offer. And be made by the offeree. As I said, if the offer is from Mary to John, then only John could accept the offer, but not Peter. Okay? So must be made by the particular offeree. Mirror the terms, mirror image. As I said before, not the counter offer. Be written in oral form or implied from conduct. So as mentioned earlier, you can have a written contract, you can have oral contract, conversation, agreement in oral conversation, could also be implied from conduct, behavior. Okay, it doesn't need to be in written form, but you could be based on your acts, conduct. Cross offers. Two identical offers do not constitute an agreement. So if you just look at these points, you may feel very confusing, right? Confused. Cross offers. Two identical offers do not constitute an agreement. What does it mean? So better look at examples. An example in this case is a precedent, of course. The two parties wrote to one another on the same day. P, plaintiff, offered to buy 800 tons of iron at this price per ton. The defendant, the other party, offered to sell the same quantity at the same price. Same, now, that means what? Two parties are making offers, and these two offers are actually the same, but they cross each other. From party A, from party P, okay, plaintiff, and also from party D, the defendant, at the same time, talking about the same thing. Held, there was no contract because both offers were made in ignorance of what the other party had done. Because the defendant did not know that the plaintiff was offering this, and the plaintiff did not know that the defendant was offering the same thing. These are two offers, cross offers, but not actually from one offer to another, up to the offeree, and the offeree can accept that offer. They just make one offer, and that offer becomes the same. I mean, two of them do not constitute an agreement. And for acceptance, silence cannot effect and communication. Because we are talking about the fact of acceptance and communication of acceptance. How the acceptance is communicated is also important. Silence cannot effect a communication. Offerer cannot stipulate that silence of the offeree is to amount to acceptance. Say, I can't say, I offer to sell you the car, right? If you keep silent, then I would assume that you would accept my offer. No, okay? In the Fairchild's case, the plaintiff wrote to his nephew offering to buy a horse, adding, if I hear no more from you, blah, 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 I will take it that the horse is mine. That means if you do not respond, right, you keep silent, then I will assume that you agree to it. The nephew did not reply in that case. It was held that acceptance had not been communicated in that case. And thus there was no contract. Okay, so acceptance could not by the way of silence. Okay, silence has no effect. Exceptions to the rule that acceptance must be communicated. Now, this is a very tricky point. If you still remember the case of Mrs. Carlo, in that case, the Carbolic Smoke Ball Company posted an advertisement, right? Mrs. Carlo, referring to the advertisement, bought and took that smoke ball medicine. But in buying that, in taking that smoke ball, it was not known to this company, right? Because the company just offers to the whole world. But the companies at that time did not know that Mrs. Carly really bought and took that medicine, right? So in a unilateral contract where communications is expressly or impliedly waived, in that case, this is a unilateral contract, so it is not a must that communication is made to the offerer. Okay, this is an exception. Okay, how about communication which is by post? Takes place when a letter is posted, not when it is received. This is even more tricky. Okay, what does it mean? This refers to the postal rule demonstrated by the Adams case a long time ago. Okay, try to read these facts first and the decision held. See whether you can understand. I will explain them to you. Okay, give you a couple of minutes. Understand? So if you find it difficult to understand, you better draw a timeline. That will help you understand the issues. Now, on the 2nd of September, D wrote to P offering to sell some wool. That letter was misdirected, only reached P a few days later, 5th of September. That same night, that means on the same day, that means 5th of September, P posted the acceptance, accepting the offer. But then only not until a few days later, 9th of September, that letter reached the defendant. But before that, the defendant already showed the Wu elsewhere. So it was held that acceptance was complete when the letter was posted by the plaintiff on 5th of September, instead of acceptance happens or took place on the 9th of September. So this shows acceptance takes place when the acceptance letter is posted, not until the acceptance letter is received. So is it fair? Seems not fair, because the seller didn't know that. The seller has not yet received the acceptance letter, right? Okay. This is from the perspective of the seller. Okay. But if you view it from the perspective of the buyer, it could also be unfair if you take it as the acceptance as 9th of September, because the buyer signed the acceptance letter on the 5th of September. So it is somewhat inclined towards the buyer, protects the buyer rather than the seller, right? So acceptance is effective on posting, even, now this is even more, seems to be quite unfair, even if the acceptance letter is lost. That means the seller has never received the letter, will not receive the letter because it's lost. So in the household fire insurance case, the defendant offered to buy shares in the P's company. A letter of allotment acceptance was posted to defendant but never reached him. How the contract was completed when the letter was posted seems very unfair, right? The difference between acceptance and revocation. Acceptance takes place when a letter is posted. Revocation takes place when the letter is received. Okay, different. But of course, there are some sort of protections, I would say, limitations to the postal rule. Limitations. The above postal rule is that acceptance takes place when the letter is posted. Limitations. Number one, it only applies to acceptances, not to any other type of communication, not applied to offer or revocation. Only applies to letters and telegrams. Okay, so these are limitations to the application of the postal rule. Some more. Does not apply to instantaneous methods of communications like telex, fax, or email. Must be reasonable to use the post as the means of communication. Now, this is also a limitation. It must be reasonable to use the post as the means of communication. And one more, acceptance letter must be properly addressed and stamped. So if you post a letter, but you didn't put a stamp on it, right? You didn't put a stamp with sufficient fare, right, on it. You didn't put a proper address on it, then it is your fault, not the seller's fault, but you as the buyer, it is your fault, right? That is one of the limitations. So under the postal rule, seems to be disadvantageous to the offerer, right? Because what? Contract would come into existence without the offerer ever knowing it. As I said, the offerer, the seller, didn't know that. Seems very unfair. But in practice, it is actually controllable. So if you're the seller, if you're the offerer, as in this case, the Howell case, the offeror can indicate in his offer that an acceptance will not be valid until he actually received notice of it in writing. So therefore, when you read the details, right, of contract documents, sometimes you may come across a statement, terms similar to the one here. So the offerer, say the employer may say that, oh, okay, this acceptance will not be valid until I, as the employer, actually receive notice of you in writing. This is to protect the offerer. So we have this kind of protection. Okay. Communication by instantaneous electronic means. Acceptance takes place when and where the message is received. Now, this is different from post. Postal rule, it is supposed to be not applicable to instantaneous methods. Email, for example. So for instantaneous communication methods takes place when and where the message is received, like email. So in the old days, we have telex. Nowadays, emails are much more common, right? Telex will confirm during normal office hour, acceptance takes place when the message is printed out, not when it is read. And the House of Lords in the UK accepted that communication by telex may not always be instantaneous. Because what? It could be because due to companies in different places. One in Hong Kong, one in the US, the other one, or one in Hong Kong, one in the UK, right? We have time difference, okay? So when received at night or when the office is closed. So it could be daytime here in Hong Kong, it could be nighttime in the US, right? Different office hours. It has been suggested that a message sent outside business hours should be communicated when it is expected that it would be read. For instance, at the next opening day, opening, say, 9 a.m. in the morning. Say when you send an email tonight, midnight, right? So we need to consider what's the opening hours the next day of the company on the other side of the world, okay? So generally accepted that same rules apply to faxes and email, okay? Similar to telex. So how about telephone answering machines? Okay, we have voice message, voicemail. I'm not sure whether your office has this kind of provisions, but still many companies are using voicemail, right? Have telephone allowing people to leave message. The presence of an answering machine may indicate that communication is not instantaneous. There could be delay between sending and receiving messages. So the basic rules should apply. Acceptance takes place when the message is actually heard by the offerer. Okay? Not when you leave the message, but when the message you left is really heard by the offerer. In fact, there was no universal rule could cover all cases. So we need to look at the intention of the parties, the sound business practice, the common practice, which one is more feasible, more common, and judging the risk should lie. So if you are talking about a big deal, multi-million contract, right? So it won't be through, acceptance won't be through telephone answering machine, right? You may have even a ceremony, right? For signing the contract, right? A press conference, taking photos and everything, right? So we have to look at all the circumstances of the case. to decide which of them, which mode of acceptance is reasonable. Okay. So here, this one, with much relevance to this context, is the electronic transactions ordinance. So you may take a look at this ordinance, chapter 553, section 19, bracket 2. If the addressee has designated an information system for receiving electronic records, then receipt occurs when the record is accepted by that system. Okay? Or when the record comes to the knowledge of the addressee. Okay? So if the addressee has not designated an information system, receipt occurs when the record comes to the knowledge of the addressee. So there are some provisions in this ordinance governing acceptance through electronic means. Okay. So remember, as I said before, in common law studies, on one side, we need to refer to common law principles. On the other side, we also need to refer to statutes, statutory requirements, ordinances. Okay. And the authority of ordinances generally is higher than common law principles. Remember that? Last lecture, still remember, I hope? Ordinances are here at a higher level than common law, right? Ordinances, the hierarchy, higher in level. All right, now here are the references and further readings for this first chapter. So traditional, I would say common textbooks, number 1, number 2, and number 3 is particularly for some cases with commentary in Hong Kong cases, contract law, okay? Number 4 and number 5, both are business law, but I would say they are easier to read than the others. They cover contract law, tort law. That's why I cited them as references for you. Okay. Relatively easy to read. Okay, you can take a look. All right. So any questions? Now, if no, I would like to brief you a bit on have you found this on Blackboard? Yes? Okay, in-class activity. So from next lecture onwards, we will have 3 mini sessions for in-class activity. So what to do, you don't need to do it now, but next lecture, I will tell you how to do it, okay? But now I would like you to start thinking of finding your group mates, okay? You will be required to do it in groups of, say, each group may have 5 students, some may have 6, some may have 4. In general, I would like to have 5 students in a group, okay? So if you have some friends, right, some peers, you would like to come together to form a group, you may do so. And I would formally issue an announcement, not now, but after this week, maybe end of this week. Because what? Because after the add-drop period. I don't want to cause confusions. You know, some students who are still in the class, I may join a particular group, but say a few days later, he decided to drop the subject. That would cause confusions. And some new students may join this class, may add to this class. But here, assuming most of you would like to stay, and you can start forming groups with your neighbors, your peers. For what? First is for this in-class activity, okay? Number two is for your seminar project, you know. Later, I will also brief you what to do for the seminar project. Later, not now, okay? Now, but then here now I would like to give you a preview. Now we are talking about contract law tonight. For this in-class activity, you will be asked to search and read some law reports cases. Those could be on contract law, could also be on tort law, okay? According to the teaching schedule, now we are on contract law, right? Later, we'll have tort law, okay? So in order to give you some brief idea, because we will not teach tort law until 9th of February, but I would like you to do in-class activity. You may search some reports about contract law. You may also search some reports on tort law. So in order to facilitate you to have some initial idea of what tort law is about, okay, I can now show you a short video about some basics of tort law, okay. So a basic principle of tort law is negligence, somewhat like careless, right? You don't care the others. That would lead to problems. And that is a very key principle of tort law.
Hello everyone and welcome to the first of our video tutorials on negligence.
Negligence.
Next video we'll be looking at the first element of proving negligence, duty of care. Just a reminder then that in order to prove the defendant liable in negligence, the claimant has to prove firstly there was a duty of care, secondly there was a breach of that duty, and thirdly that this resulted in damage. But today we're going to focus solely on how you prove duty of care in negligence. Donoghue and Stevenson is the first case to look at here, because this case established the model law of negligence.
Now, this is a very, very famous case, Donoghue and Stevenson. If you still remember during the last lecture, I showed you a video about the history of law reporting. During that video, this case was also mentioned. This was the seminal case illustrating the principle of negligence, duty of care. It's regarding the drinking of beer, right? But within that bottle of beer, there was a death nail. There you go. So you may.
Which is neighbour principle. I'm not again with you here. There's a little video link that you can look at to remind yourself of this if you go onto my PowerPoint. But for now, we're just going to focus on the principle from Donoghue and Stevenson. So Donoghue and Stevenson was massively important because it was a case that came up with an original precedent that manufacturers of products owe a duty to the ultimate consumers of their products. But this case is also important, particularly for duty of care, because it established the neighbour principle for deciding when a person will be under a duty. In this case, Lord Acton famously said, the rule that you are to love your neighbour becomes in law you must not injure your neighbour. And the lawyer's question, who is my neighbour, receives a restrictive reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee will be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directed my mind to the acts or omissions which are called in question. Luckily, you don't have to memorise the neighbour principle that I've just read out, but the reason that I've read it out to you is to show you that the neighbour principle was basically saying that you owe a duty of care to anyone who is close to you, and that you can reasonably foresee is likely to be injured by your acts or omissions. But you could hear there from what Lord Atkins said that the neighbour principle is quite waffly and not very clear. So in the next case of Caparo and Dickman, the judges took the opportunity to give a much clearer test for establishing when a duty of care would be owed. So in Caparo and Dickman, the neighbour test or the neighbour principle was replaced by a three-part test for establishing a duty of care. So you have to firstly look, was the damage or harm reasonably foreseeable? Was there sufficient proximity, meaning closeness, between the claimant and the defendant? And is it fair, just and reasonable to impose a duty? And what we need to do now is look at some cases that help to illustrate each of these stages. So we're going to...
Here, this test is important. Neighbor test, the neighbor principle that would affect the establishment of negligence or not. So in order to prove this test, there are three parts. First was the damage or harm. Say, talking about the slippery case, right? Say when you go to a toilet, the floor is wet, right? And then you step on wet floor, and then you fall down, getting hurt, right? Then your hurt, your injury is a damage, is a harm. Was that harm reasonably foreseeable? That is first question to ask. Second, is there sufficient proximity between you as the claimant, C, D as the defendant? Who is the defendant? The owner, the building owner, the toilet owner, okay? Could be a defendant. And could also be some other parties, which I would tell later, okay, when it comes to tort law. Number three, is it fair, just, and reasonable to impose that duty of care? The toilet cleaner, the toilet owner has the duty to care about the toilet user, okay? So these are three main principles.
If the damage or harm was reasonably foreseeable. This case, unreasonably foreseeable, is the case of Kenton Griffiths. And this is where the claimant was suffering an asthma attack, and an ambulance took 30 minutes to arrive. And the principle from this case was that it was reasonably foreseeable that a claimant would suffer some harm of the failure of the ambulance service to arrive in a reasonable amount of time.
我刚刚写我那个是那个，因为我来，什么其他头？
Jolly Sutton, you can see that the council had some land where there'd been an old boat abandoned, and the council knew about it and knew it was all dilapidated, but they left it there. And some 14-year-old children were playing on boats, and one of the boys actually propped the boat up and was underneath it, pretending to be a mechanic or something. And unfortunately, the boat fell on him and he was left paralysed. And the issue here was this reasonably foreseeable? And the council were trying to argue that it wasn't reasonably foreseeable. How could they possibly predict that someone would lift a boat up, climb underneath it, and be injured when it fell on them? And you can sort of see that point there. However, the House of Lords in this case said that it was reasonably foreseeable that some injury would occur if children played on or around it. And so the defendants had been negligent. So they were sort of saying there that you didn't have to foresee the precise type of harm, but you just had to foresee that some injury would occur. Kenton Griffiths and Jolly and Sutton then, both of these cases, the court decided that the harm was reasonably foreseeable. So it's nice to contrast those cases with a case where there was a different outcome, where it was held not to be reasonably foreseeable. And this is the case of Ball Hill and Young.
Okay, this is a further elaboration of another case, Ball Hill and Young. I would explain this case to you later when we come to tort law. But here, I think you have at least some initial idea about negligence, which is the initial part of tort law. And if you want to learn more, I think you can, right, this link. Or let me see whether okay, I think you can copy this link, right? This video is a recorder, so you can copy this link and then watch this video later when you have more time, okay? So, or now you can take a picture of this link, okay? And okay, then if you have already formed your groups, that's good. I will ask you for your group members next week. So watch out for my announcement. I will send you a message or when we meet next time, okay, next Monday, okay? Then next time, you better bring along like your notebook or smartphone or iPad because we will have that in-class exercise. Mini sections for you to guide you to search and read some reports. Okay. So if you have questions, you may ask now. Any questions? If no, thanks for coming. See you next time.